First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and he shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on the docket today, North Broward Hospital District et al. Versus State of Florida Agency for Healthcare Administration. Is the appellant ready to proceed?
Good afternoon, Your Honors. May it please the Court, I'm Steve Brannick of Brannick Humphreys and Vermin here for the hospital providers, the appellants. I'd like to reserve 5 minutes of my time, if I may, for rebuttal.
Sure.
The question is whether the legislature, in amending Section 409-905 of the Florida statutes, retroactively overruled the clear holding of this court in Lee Memorial Gulf Coast, prohibiting ACA from retrospectively auditing prior authorized paid claims absent suspicion of fraud or abuse. It did not. First, the amendment does not change the central holding of Gulf Coast, and it certainly doesn't change the holding of Gulf Coast in the way that ACA suggests. And secondly, if it did, it would be an unconstitutional substantive change retroactively applied to our clients. So let me start by talking about what the amendment does and does not do, and in particular, what the amendment left in place in the statutory framework.
So
First,
you don't think the amendment was a clarification of prior law?
I think that if the amendment is interpreted in the way we've suggested in the brief, that would be a clarification. If the amendment is interpreted to allow ACA now to retrospectively audit the same claims that the Gulf Coast said they could not audit, that would be a substantive change. It would be unconstitutional. So first, the amendment retained the key feature of the statute, which was central to the Gulf Coast decision. Section 409-905A still states that, quote, upon implementing the prior authorization program for hospital inpatient service, the agency shall discontinue its hospital retrospective review program. This court held in the Gulf Coast case that sentence prohibited the retrospective audits that ACA tries here. The statute prohibited general retrospective audits before, and it still does. Secondly, and equally important, the statute leaves in place an unchanged 409.913. 409.913 is the statute that gives ACA the authority under certain circumstances to conduct audits.
And do you think it's relevant that it's untouched? And secondly, the definition of overpayment is untouched.
Exactly. So the 409.9132 tells us that ACA can conduct retrospective audits to determine fraud, abuse, overpayment, or recipient neglect. There's no allegations of fraud, abuse, or recipient neglect here, so we're talking about overpayment. And as Your Honor just observed, the definition of overpayment that this court relied upon to prohibit the retrospective audits is still there in the statute. The statute.
And that's one clarification I wanted to make, that these claims are identical to Gulf Coast case, that this is a reimbursement based on a pre-existing authorization, finding of eligibility, et cetera, duration approved, with the application later of the alleviated definition from the federal. So we've got the same set of facts. We do not have in this case an infused fraud or mistaken billing, none of those aspects.
Absolutely. We're basically here back on the Gulf Coast facts, and the only issue is whether the amendment changes anything. So, as I said, it doesn't change the critical sentence of 505, and it doesn't change the critical sentences in 913. Third,
Let me ask you a question that is on my mind, and that is, what if we were wrong in Gulf Coast? I went back and looked at the motion for rehearing that ACA filed in Gulf Coast and the appendix that the appellees attached to the answer brief. And isn't there a rational explanation for the legislature leaving that sentence in that we relied on in Gulf Coast? If ACA is correct, that we incorrectly relied on a sentence that actually referred to an obsolete program?
Well, first,
And if that's true, what's the consequence if we decided that Gulf Coast was wrongly decided?
we don't think that Gulf Coast
I know you
was
don't.
wrongly decided. I mean, this court looked at that argument and decided that the statute prohibited retrospective audits in general.
I know what
not
we
just that
decided.
one
I was on
particular
it.
Program.
So I was on the case. So, but sometimes courts make mistakes. What if we wrongfully, incorrectly, relied on a sentence that actually referred to, and if you look at the 2001 amendments to the statute, what that sentence refers to is an obsolete program of review that was superseded by a new program. So that would explain why the legislature would not remove that sentence from 905, right? If that's true.
Yeah. I've got kind of 2 points in response. One is kind of a simple point, but the interpretation that Your Honors made of the statute is exactly the same interpretation that ACCA made of the statute in 2002 after the statute came in place, and for the 8 years that it was conducting these audits between 2002 and 2010. So you're in agreement with ACCA as between 2002 and 2010. Secondly, if Your Honors were wrong and the legislature meant to change your opinion, I think they would have done 2 things. I think, number one, they would have eliminated that first sentence.
Why, if it's referring to an obsolete program, why would you need to remove it? I mean, you could to clean up the statute, but you don't need to remove a reference to an obsolete program, right?
Right, but if this court, if the legislature were truly concerned that this court had gotten it wrong, I think the legislature would have eliminated that sentence, and they would have, in fact, then amended 409913 to make clear what ACCA's authority was, and that ACCA authority did have the power to do the.
But I don't think there's any
retrospective
debate, right, that ACCA has the authority to do retrospective reviews
Under the
for
circum-
mistakes,
Yeah, under
for
the
mistaken overpayments, right?
Yeah, under the circumstances, yeah, in 409.913, including overpayments. But as this court observed in the original Gulf Coast decision, these were not
But we got to be
overpayments.
careful with semantics here. So when we say overpayments, we've got a definition in the statute we have to follow. So when we say, their retroactive audits are allowed, certainly they are. Look at 913 and giving that directive. But we got to be careful with our semantics, right?
Oh, absolutely. And ACCA's limited to the authority granted to it by 409913. And 409913 tells us exactly what an overpayment is, and an overpayment excludes prior authorized claims, as this court ruled in the first Gulf.
Well, is it your opinion that the added sentence, the however, comma, that we're really looking at here, it's interesting to me, the verbiage, because it talks about, it's talking fraud and mistake language. It's tracking 913 purpose to me. And then it's interesting, we have this or, for other reasons that did not rise to the level of fraud or abuse. Now, arguably, could you say, well, that opens the door to any form of retrospective audit, or does that cover the 913 section that says we don't have to have fraud or, ill intent? We can also retrospectively audit under 913 if we see a mistake in claim billing, for example.
Right. If you look at 409, that sentence that was added to 409-505, it's all referring back to overpayment, in which an overpayment is suspected due to a mistake or submission of an improper claim or for other reasons that did not rise. All of those relate back to overpayment. So, everything certainly relates back to 409-913. It's absolutely clear that sentence is doing nothing more than just ensuring that all of the circumstances in which an audit is allowed under 913 are incorporated into.
So your argument is then, and just so you can relax a little bit, I'm going to add 5 minutes to both sides. Your argument then is that under current law, ACCA cannot audit hospitals for overcharging for medical services for unlawful aliens, even now with the amendment?
It can if it's based on fraud, abuse, or recipient neglect, but it can't if it's based on an overpayment, because that overpayment was already prior authorized by by ACA. And that
So
leads me
your
to-
argument is that by authorizing emergency medical services, not a specific claim, services, and if you look at the final bill analysis on CS for 731, I think the total recoup by the state of Florida is now over $1 billion under the Medicaid Integrity Program. I know that's not specifically just the unlawful alien audits. That number was 53 million as of 2020. But, I mean, seriously, we rendered the decision in Gulf Coast. The legislature immediately adds that sentence. The final bill analysis refers to our decision and says, ACA says that our decision was wrong. The legislature adds the sentence, which my colleague just noted, refers to any reason for the overpayment, and it's appellant's position that ACA still cannot do a retrospective audit of Medicaid overpayment for unlawful alien emergency medical services?
Absolutely, Your Honor. And there's kind of an awful lot to unpack in that question. So let me start with first that last phrase, that talks about or for other reasons that do not rise to the level of fraud and abuse.
It couldn't be any broader than that, right?
Right, but if you again, I think that relates back to overpayment, and it certainly makes clear that it's talking about 409-913, which of course has been unchanged since the statute. So if that sentence does what they say it does, that means that ACA can audit for any reason, then that's completely contradictory to the first sentence, the sentence immediately before it, which says ACA cannot conduct retrospective audits, and then with the next sentence in the statute say ACA can conduct retrospective audits for any reason. That makes absolutely no sense at all.
But the inverse, under your analysis and logic, the inverse is also nonsensical, right?
Oh, I don't believe so.
The inverse is, hey, you can conduct retrospective audits, but no, you cannot conduct retrospective audits?
No, but
That's the inverse of your argument.
The statute specifically says you can conduct retrospective audits pursuant to 409.913. And then 409.913 tells us exactly when they have the authority to do retrospective audits.
Back to the state, to the laws of Florida, 2020, section, I think it's 156. I don't think I saw it cited in your initial brief, but the appellee certainly cited it. It's not in the statute, but it's in the laws of Florida, where the legislature said the intent is to clarify and confirm existing law. You had mentioned that. You think that actually supports your argument? Can you explain to us how that is?
Yes, I think that there was a legislative concern that this court's decision had restricted the retrospective audits to fraud and abuse. And so the legislature wrote a clarification that indicated that, no, it's not just fraud and abuse. If you want to read the decision that way, I think that's an unfair reading of the decision. But if you want to read the decision that way, we want to make clear that all of the circumstances in 409.913 are subject to retrospective review. So it just incorporates all of the language of 409.913 into the prohibition. So that's the clarification. If you're going to now read the statute that they can do a retrospective audit for any reason, that's very, very far from a clarification. That's a dramatic substantive change. Under this court's decision in Gulf Coast, they would not be able to do the retrospective audit. Under their interpretation, under the amended statute, you would be able to do a retrospective audit. That's a very dramatic change, and it would certainly interfere with the substantive rights of our client. And second, it doesn't really matter that the legislature called it a clarification. Courts look at the substance of the statute, not what the legislature tries to call it. You look at what the statute does, not what the legislature says. And courts have said very specifically, be very wary about attempts to do substantive changes to a statute under the guise of a clarification. The McKenzie check case that we discuss in our brief out of the Florida Supreme Court makes that point very clear, and the Dean Wish case out of the second DCA also makes that court very clear. And that kind of leads me to that recent controversy rule, which I think Your Honor mentioned. The recent controversy rule doesn't apply for several reasons. First, it only applies when the original statute is ambiguous or unclear. And this Court said several times in its discussion of the previous statute that there was nothing unclear about it, that the plain language compelled this Court's ruling. So there's no room for the application of the recent controversy rule. The Madison case, which they rely on so strongly, is very different. In that case, it was a very close question. The Court acknowledged it was a close question. There had already was conflicting authority among Florida courts. So when the legislature stepped in very quickly and made the clarification, the Court said, under those circumstances, when the original statute was ambiguous, it makes sense to now take into consideration what the legislature has done in interpreting that original statute. But that's very different from this case, where this Court determined that the plain reading compelled the result. And then there's nothing recent about what the legislature did here. How in the world is the legislature in 2020 supposed to divine the intent of the legislature back in 2002? This is 18 years later. The McKenzie Check case and the Dean Wish case both say when that many years have passed, and in those cases it was like 6 or 7 years, the recent controversy rule just doesn't apply. So I see my yellow light is on.
May I ask the clerk, was the 5 minutes added to their time? So you actually have some more time.
Okay,
so I'm sorry, I'm not going to let you sit down quite yet. So let me ask you again about whether, I know you disagree, but what is the consequence if this panel were to decide that the panel in Gulf Coast decided the case incorrectly? Forget the legislative amendments, forget whether or not the legislature was essentially abrogating the decision. What if we decided the decision was incorrect? What is this panel's authority in that situation?
Well, I think first you have to go in bank to do that.
Why is that?
Because this original panel said that the plain meaning of this.
No, I understand.
applies.
I'm not arguing that if this panel were to decide the prior decision was wrong. I'm not arguing that it's, quote, not on point. I'm asking you, what is the consequence of a panel deciding that a prior panel decision is incorrect?
Well, putting aside the question of whether it has to be done in bank or not, if the second panel essentially overrules the first panel, I gather that the law as interpreted by the second panel would control. I don't think that this court could do that without going in bank.
Well, why do you think the court can't do it without going en banc?
Because the original, the way that Gulf Coast was originally decided in the first place, which was based on.
I understand. We're saying this is the exact same question of law, the exact same set of facts, and what if this panel were to decide the prior panel decision was incorrect?
I think it would be just like any other case where a second panel disagrees with the first panel, and to my mind, that's got to be done in bank. I don't think the second panel can overrule.
And I know you're very knowledgeable, and before I forget, I want to compliment your brief. The briefs on both sides were excellent. But I'm asking you why we have to go en banc to overrule the prior panel.
I think just because of the circumstances of this case, because the recent controversy rule doesn't apply, because the first panel.
I understand that. Let me try it a different way. Forget this case. Does a subsequent panel have the authority to overrule a prior panel on the exact same question of law?
I don't believe so, Your Honor.
Why not?
Because I think it's well settled in Florida courts that that's the whole purpose of in-bank review. Is if a
I know it's the purpose. I know we can review it en banc. Do we have to review it en banc?
Well, let me just put it a little more practically. I mean, I certainly see situations all the time where a second panel arguably conflicts with the first panel. But if there is a true conflict, and if this court were to declare that the first Gulf Coast decision was wrong, if there was a true conflict, that would almost always lead to in-bank review. Certainly second panels disagree with earlier panels all the time. And then you have the argument about whether, well, is it a true disagreement or not, if the circumstances changed or not. And sometimes that'll lead to in-bank review or not. But in this case, when the two cases are on all fours and decided exactly the same way, I don't know how the second panel could overrule the first panel without presenting that conflict to the entire court. That certainly would be the
I understand maybe the
most jurisprudentially prudent way to handle it.
I understand it may be the preferred or the prudential way. My question to you is it required under the Constitution?
Off the top of my head, I could not
That's fine.
tell you the answer to that.
That's
that
fine.
question.
We could all have a seminar. Mr. Padovano could probably give us one, all on that topic. But aside from supposing, let's bring it back down to, I want you to clarify something. It is not your position that there are no retroactive audit powers of ACA, period. That's not your position. Your position is, in these circumstances where there's been pre-authorization, DCF found eligibility, approved duration, etc., that you can't later apply an alleviation definition to say, although we told you we approved 3 days in the hospital, now we're going to say we're only going to approve 2, even though you provided those services based on our prior approval. That's what you're saying is that circumstance, a retroactive audit is restricted. Just wanted to make that perfectly clear. And it's not your position that there is no retroactive audit power of ACA.
Yeah, our position is that the legislature has told us exactly what ACA's power is, and the legislature has told us that in 409-913. This court has already interpreted 409-913. Nothing has changed about 409-913. End of story as far as we're concerned. I'd like to make sure I save a little bit of time for rebuttal. Thank you.
And we'll add 5 more minutes to the appellee's time.
Thank you.
Thank you.
Good afternoon. May it please the court. I'm Daniel Nordby from Schutz & Bowen, representing the Agency for Healthcare Administration. With me at counsel's table is Tracy George from the agency. Unless the court would prefer otherwise, I'd like to focus my limited time on 2 principal questions. First, did the legislature's 2020 statutory amendment abrogate this court's interpretation in Gulf Coast?
To be fair to the other side, sorry to change your course of argument here, but I'm going to ask you, your brief hinted that our decision was incorrect in Gulf Coast. Do you think that decision, aside from the question whether the legislature abrogated it, do you think it was incorrect?
I'm conscious of the fact that 2 members of my panel were on that panel in
Right.
Gulf Coast. It is the agency's position that decision incorrectly interpreted the statute and that the legislature's statutory amendment the next year was intended to abrogate and did abrogate that decision.
If that panel decision was incorrect, can this panel overrule it under the Constitution?
We've certainly not briefed the prior panel precedent rule. I know that the Florida Supreme Court, in its opinion, adopting the en banc rule, had some commentary about the authority of one panel to issue a decision inconsistent with the prior panel. Without the benefit of research and briefing, though, I hesitate to weigh in much more on that. But more importantly, we don't think you need to get there because of the legislature's action here, which makes it distinguishable from the Gulf Coast.
And the appellant's brief noted that ACA did not seek discretionary review in the Supreme Court of the prior decision, but there was no basis for discretionary review, was there?
I'd agree with that. Out of all the bases for discretionary review in the Constitution under Article 5, the Gulf Coast decision did not involve constitutional claims, for example. Obviously, it didn't involve public utility claims or death penalty claims. It didn't conflict with a decision from another district court of appeals. So the first Gulf Coast decision did not provide an obvious basis to seek discretionary review, and the agency takes the Supreme Court's jurisdiction seriously.
Mr. Norby, I know if you had had a hand in redrafting perhaps the statute, it would have been much more clear. But why no touch to the overpayment definition, which seems to be quite important to me?
I appreciate the question. So 2 points on that. The first is that the definition of overpayment. Well, let me start first, if I could, with 905 and then turn to 913. So 409-905-5A Says, however, this subparagraph may not be construed to prevent the agency from conducting retrospective reviews under Section 409.913, including but not limited to the remainder of that sentence. So we think that the amendment to 409.905 is written in broad language. Now, as to 913, Judge Thomas, your question, the definition of overpayment in 409.913.1e says any amount, overpayment includes, not means, but includes any amount that is not authorized to be paid by the Medicaid program, whether paid as a result of inaccurate or improper cost reporting, improper claiming, unacceptable practices, fraud, abuse, or mistake. We think the flaw with the appellant's argument here with that definition is reading the word authorized in 409.913 as though the statute said that is not prior authorized under the prior authorization program. We think a better reading, a reading of authorized in that sentence more consistent with the purpose of that statute, is that authorized should be given its plain and ordinary meaning. That an overpayment includes any amount that the Medicaid program does not permit to be paid. And it could be for any reason. It could be for improper claiming. It could be for fraud, abuse, or mistake. But if the definition of overpayment includes all of those things, the appellant's interpretation is essentially undermined by their concession that a prior authorized claim can be audited for fraud or abuse. I think they've conceded that. Even if a claim receives prior authorization, if there's suspicion of fraud or abuse, it can be subject to a retrospective audit. Well, if that's the case, the same definition says it can also be reviewed for improper claiming or mistake or any of the other reasons in the definition of overpayment there.
And in this case, those are all absent. I haven't heard, correct me if I'm wrong, but isn't it ACA's position in these cases, as it was in Gulf Coast, that yes, we authorized the duration earlier, but after the fact, we've looked back and applied and alleviated, and so now instead of 3 days in the hospital, we're going to pay for 2 days in the hospital. There's no mistake in billing. There's no accountant that, dropped a period. This is, we changed our mind, or now we're going to change the rules after we've authorized you to hospitalize and provide services for this undocumented worker. We said we approved 3 days, but now we mean 2.
So in the context of these audits here, and again, this is a case arising out of a breach of contract claim rather than the administrative proceeding, the portion of the definition of overpayment that includes improper claiming we think would apply to here. If a hospital has claimed a certain payment that is improper upon further review through this auditing process, that would be an overpayment. It's something that Medicaid didn't authorize to be paid, even if it was prior authorized on the front end. ACA determined on the front end that it should be prior authorized. ACA still has the authority to audit the claim, to review the records, to have an expert peer look at the records, and to present a case as to why that was improperly claimed. And in fact, ACA did that in a lot of cases, including Gulf Coast. Gulf Coast arose out of a fully adjudicated administrative proceeding at the Division of Administrative Hearings, at which both sides put on an expert as to whether the claim was proper or not. This case is, as I said, a breach of contract action, and we raised in our summary judgment filings below the fact that of the 9 audits actually at issue here by these 3 providers, 7 of the audits, the providers voluntarily paid ACA the disputed amount and did not request an administrative hearing. 2 of the 9, a default final order was entered against the providers after they failed to make any payment or they failed to request an administrative hearing. We have an affidavit in the record at 1778 to 81 from an ACA employee in support of our motion for summary judgment on our affirmative defenses that shows that even if this court were inclined to agree as to the main issue that's been briefed here, there'd be alternative grounds for affirmance on ACA's affirmative defenses, which were fully preserved on this record here. The trial judge didn't need to reach them because she agreed with us on the merits claims here. But as to the specific audits that were at issue here, the providers here never challenged them the way that the provider in Gulf Coast did. And the other thing that this panel did not have in the benefit of in Gulf Coast, but does have here, is further information about the hospital retrospective review program that's referenced in 409.905. This court didn't have that information in Gulf Coast, in part because of the procedural posture of that case. I believe that ACCA filed it as an attachment to its motion for rehearing, but not in the main part of the appeal.
Can you clarify what you mean by that?
About the program?
prior program.
I will. And again, this is something that the court did not have the benefit of in Gulf Coast, is the information about the hospital retrospective review program. Prior to the effective date of prior authorization in 2002, ACCA reviewed a percentage of all of the claims after the fact.
Right, that was a 10% random check, right?
They did, after the fact, as part of a hospital retrospective review program. The court in Gulf Coast made reference in the opinion to the fact that ACCA hadn't explained what this program was and why it was different from what was being done here with retrospective reviews by the Office of Medicaid Program Integrity. That was a program used on the back end of payment to try to verify the claims. What ACCA does under 409-913 is an entirely different function.
You're saying there's a difference, the project and then the MIP.
I'm saying that the Office of Medicaid Program Integrity has a responsibility under the federal regulations to ensure the integrity of the program. What ACCA was doing in this program that was in the statute says the agency shall discontinue its hospital retrospective review program. It has in fact discontinued its hospital retrospective review program. What the statute doesn't say is the agency shall halt all retrospective reviews of paid claims.
But didn't, under the project, ACCA used MIP to do the retrospective audits?
Under the prior program, just to clarify your question?
Yes.
No. That review under the hospital retrospective review program was done in ACCA's Office of Medicaid, not the Office of Medicaid Program Integrity. They're two different functions. One is an initial claims review process. The other is intended to review claims that have been paid to determine has there been an overpayment, has there been fraud or abuse. That second function, the 409-913 function, is what ACCA was using for the authority for this particular program, not the discontinued program.
And in fact, that program, as I understand it, could be compared to a program where, say, at the airport, you have a policy of just checking 1 out of every 10 bags. It was almost just a randomized check on certain payments, totally different than the current integrity program, whereby they review payments in detail, as I understand it, and then go back and say, wait a minute, as my colleague said, 3 days was too much. You were only authorized to provide 2 days emergency service. Is that a fair description?
That's right. They're different programs with different functions. And I just want to clarify that the prior authorization under the statute is for the services. The specific claim and claim amount is not something that's prior authorized on the front end. So ACCA's auditing function is intended to go back, and in this case, this program developed out of information from the federal government.
Right, no question. It's authorization on, I get it when we say, I authorize 3 days in the hospital. Duration is different from when I get the bill for that 3 days. You've charged me for 3 boxes of, Kleenex at $100 per box. That's over billing. I get that. It's the core issue of changing your mind after the fact and saying, I told you we would pay for 3 days, this emergency medical condition. We checked the boxes. That's a 3-day hospitalization. And then after the fact saying, well, now we're only going to pay for 2 days. Only based on a change in definition from duration at the time to an alleviation definition issued by or reminded when CMS said, Florida, we remind you, we more strictly, apply alleviation. You should do that in the future.
I understand your concern, and the hospital providers always have an opportunity to challenge ACCA's audit determination through a petition to the Division of Administrative Hearings. In the 9 audits at issue here in this appeal, they didn't take advantage of that. They did not request an opportunity to make the sort of arguments that you just raised, that in fact they should have been authorized for the 3 days rather than the 2 days.
They didn't challenge the merits of the audit.
They didn't. In fact, in 2...
Now tell me about Gulf Coast. Go back to Gulf Coast. That was ACCA's argument on rehearing, at least, in Gulf Coast, that, and aside from the idea of whether it was raised for the first time, I don't think it was, but The argument that ACA made in rehearing, and I think in the case, was no, this prior program has been discontinued. We are relying on 913 and the Medicaid Integrity Program. Yes, we may authorize 3 days in the hospital for injuries resulting from a car accident, for emergency service, for unlawful aliens, but when we get the documentation of that treatment, and we see, I'm not a medical expert, but we see that no, under the facts of that patient, only 2 days was authorized. The provider is then allowed to challenge that in a 120-57-1 hearing on factual disputes.
They're absolutely entitled to petition, to go to DOA, to have an administrative law judge resolve any disputed issues of fact on that. And that was done in a number of cases by a number of providers, including Gulf Coast.
So here, 9 audits, the appellants, correct me again, 7 were not challenged, right?
None of the 9 were challenged.
In 120.
Just to clarify, 7 of the 9, the providers paid ACA the amount that ACA said was due. In 2 of the 9, the providers did not respond at all, and default final orders were issued.
That could be an economic decision, not necessarily on the merits.
But,
no, I agree with that, but just my
but their argument is, we're not going to challenge the merits of your audit. We're going to claim that we have a substantive right under the Gulf Coast decision. The legislature had no authority to change it, and you owe us all this money.
Yeah, and I don't know why specifically they did, but just to Judge Thomas, to your point, that goes to an alternative grounds for affirmance here, which we've raised affirmative defenses of res judicata, administrative finality, collateral estoppel, accord and satisfaction, waiver, failure to exhaust administrative remedies, voluntary repayment doctrine. Record pages 1968 to 1978. Is our motion for summary judgment, asking the trial judge to resolve our affirmative defenses as well as the main claims, so that we would have had an opportunity to have everything here. But this court certainly has the authority to affirm on alternative grounds if you don't agree with the main arguments we're making here as to the legislature's clarification.
Under the
of the statute.
Tipsy-Coachman doctrine.
I'm sorry?
Under the Tipsy-Coachman doctrine.
That's right. Of course, we'd ask you to affirm on the principal grounds that the parties have briefed here. We do think
Because isn't that important that we address the principal grounds? Because you correct me if I'm wrong, but as I understand the appellant's argument is that it has to be logically that the state of Florida has no authority under the current law to audit prepaid claims for unlawful aliens for receiving emergency medical services. That to date, according to the House bill analysis in 2020, had recouped $58 million. Isn't that their argument? There's no authority to do that.
Judge, I think their argument, to be charitable to them, is that ACA has no authority to audit claims that have been prior authorized, except in the case of fraud or abuse.
Understand.
But I don't see how that
excluding fraud.
But I don't see how fraud and abuse can be excluded from that without also excluding improper claiming and mistake, because they're part of the same definition of overpayment in 409-913.
And all of this started in 2009 by the Inspector General's demand that the state of Florida audit these payments for emergency services for unlawful aliens.
Judge, this series of cases has had quite a history. Ms. Erdy and I have litigated a few of them together. It's been going on for a while now. I'm hopeful, though, that with the legislature's clarification, that we're reaching the end of it here. I don't think there's any question that the legislature intended to clarify the state of the existing law here. The provision of the chapter law, Chapter 2020-156, Section 39 that we've referenced in our briefs. The appellants referred to that as part of the markup pre-enactment. That's just not accurate. That's part of an enacted chapter law. It's every bit as much of the law of the state of Florida as something that's codified in a section of the Florida statutes. It's subject to bicameralism and presentment to the governor. It's been signed off on. That is the express legislative intent of what this statutory amendment was intended to do. So the plain language of the statute and the adopted statement of intent both show an intent to clarify the meaning of 409-905 in direct response to this Court's Gulf Coast decision. This Court's decision mentioned specifically that it construed the statute to prohibit ACCA from conducting these retrospective reviews, except in the cases of fraud and abuse. The statutory amendment here specifically says that that the subparagraph may not be construed to prevent retrospective reviews, including but not limited to reviews in which an overpayment is suspected for various grounds. We've also cited, of course, the recent controversy rule that the second DCA applied in Madison at Soho 2 condominiums. There's a subsequent second DCA case that my friends on the other side have cited that distinguished Madison, but it distinguished it on the grounds that there was no clear legislative intent to clarify the prior law. That is the case here. It was the Davis-Weeks decision, I believe, said there was no clear legislative intent to clarify the existing law. As I've mentioned, we have a clear intent to modify the existing law here.
Of course, we look to the plain language of the statute. Let's, for argument's sake, since we've covered it in the briefs, look at the Senate bill. Misstates the statute number one. But secondly, do you think that the Senate bill blurb over what our case in Gulf Coast meant or the holding, do you think they correctly summarize that in the bill? I don't. Do you?
I don't think it was I don't think it was accurate in all respects, no. And we certainly, I hope, made clear in our briefs that we think a legislative staff analysis is entitled to some weight, but certainly not the same weight that the plain language, the expressed legislative intent, and other indications of intent should be given here. The Florida Supreme Court and this Court have stated that a legislative staff analysis or legislative history cannot be used to contradict the plain meaning of a statutory provision, but it can be used as further support for what this Court interprets the meaning to be. We think that that's the case here. Judge Thomas in the middle had a concurring opinion about a year ago this week, actually, in Vickery versus City of Pensacola, in which he explained exactly that use for legislative history and legislative staff analysis, that can be used appropriately to confirm an interpretation that is apparent from its plain text, not to contradict it. We think that's what the trial court did here, and we think that's what this court can do if it wants to consider the staff analysis at all. We think our arguments here have the same amount of weight and should be given the same amount of weight, even if you decided that all of the staff analysis should be thrown out and not given any consideration whatsoever.
Counsel, would you care to weigh in on the interesting debate about the en banc rule, prior panel precedent issues that Judge Thomas in the middle raised?
We don't have any.
To be fair, you should have to respond, since I did use a lot of the appellant's time.
I'd mentioned that I'm aware that the Florida Supreme Court, when it adopted the en banc rule, had some statements about the confusion that can result when a subsequent panel is arriving at a different result from a prior panel. It can make it hard for attorneys to advise clients if they're uncertain about what the state of the law would be absent en banc review. In this case, though, without the benefit of briefing and client direction on that specific question, I'm hesitant to weigh in much more than being aware of the debate. I think there was a Florida Bar Journal article about it recently that I haven't had a chance to read yet either. So I'd hesitate to weigh in more than that with my apologies.
But you're not aware of anything in the Constitution that prohibits a subsequent panel from overruling a prior panel, are you?
I'm not aware of anything expressed in the Constitution.
In fact, the Constitution provides that all DCA decisions shall be made by 3 judge panels, correct?
It does. My final point I said I would make here is that if you agree with us that the 2020 amendment to Section 409-905-5A abrogated and was intended to abrogate this court's statutory holding in Gulf Coast, the trial court properly gave effect to the 2020 amendment when it applied it in the context of this case. Specifically, the final judgment here applied the recent controversy rule and concluded that the amended statute was a legislative interpretation of the original law and not a substantive change thereof, and therefore, quote, retroactivity principles do not apply. We cited Judge Badalamente's decision for the second DCA in Madison at Soho 2, discussion specifically beginning at page 1116 of the Southern Third Reporter, which outlines the recent controversy rule and where it should be considered to come into play. There was an argument made on the other side that this statute had been around for a while before this amendment took place. That's true. The statute had been around, but there had not been a controversy about the meaning of the statute until immediately before the legislature acted here. In fact, ACCA had been applying this particular program, had been going to DOA when providers had sought review, and had adjudicated several cases before the Gulf Coast case with no real dispute over the meaning of the statute. Those cases were litigated as essentially battles of the experts as to how long, how the claims were and so forth.
That's an interesting point to reiterate that the providers have due process. They can challenge these audit findings that say we've overpaid you. They're entitled to, there's no dispute, they're entitled to a full 12057 hearing and appeal rights under 12068.
There's absolutely no dispute about that. The record shows here that when this process happens, there's a preliminary audit report that the agency gives to the provider with an opportunity to provide comment. Then there's a final audit report, which provides a point of entry under Chapter 120 to an administrative proceeding under 12057 at DOA. And after that, there's a final order issued that's appealable to this court, as Gulf Coast did, but as the providers here did not do. Providers here did not take advantage of the point of entry that was provided to them under 120. And so,
but that leads to, I think, their argument that you can't, under your, if your argument prevails, their substantive property rights have been violated.
They make that argument that they have a vested contractual right not to have their claims for Medicaid funds audited by ACCA.
At all.
Well, they would say, except in the cases of fraud and abuse, although the statute also includes in that same definition improper claiming. But the Medicaid statutes impose, and the Medicaid regulations, both state and federal, impose a number of record-keeping requirements on these providers that are entirely inconsistent with the idea that a claim is prior authorized, it's paid, and that's it. That there's no authority, no matter what information comes to light, for ACCA to come and audit that, including in the case where the federal OIG tells ACCA that it should investigate the claims because the federal government believes that it overpaid the state of Florida for some of these claims.
And they pay 55 to 60% of the Medicaid burden.
They do. And since we just think that the statute, under its plain language and in light of the legislative intent here, should not be interpreted in a way that ACCA is prohibited from taking that action. I see my time's expired, so unless the panel has other questions, we'd ask that the judgment be affirmed either on the grounds that were briefed or on the alternative grounds that I mentioned. Thank you very much.
Madam Clerk, please allow the appellant 5 total minutes.
Thank you, Your Honor.
Without objection by appellee.
I want to start
No, I
by-
mean 5 minutes flat, I'm sorry. Just 5 minutes, so basically an additional 56 seconds, I'm sorry. So the appellant has 5 minutes flat.
Thank you, Your Honor.
5:04 is okay.
I want to start by saying we shouldn't forget that the narrow question that was briefed in this case, and the question that was before the court, is whether the one sentence that was added to 409-505 changes anything. And for all of the reasons I talked about in my main argument, the fact that it left the key sentence in 505 unchanged, the fact that it didn't change the language of 409-913, the fact that we still have the doctrine of administrative finality to consider, all of those things suggest that that sentence doesn't change anything. Now, I don't want to beat a dead horse here, but I want to make it clear, we are not arguing that ACCA does not have the authority to conduct retrospective audits. 409.913 tells us exactly when ACCA has the authority to conduct retrospective audits. This court already extensively analyzed 409.913.
You mean only for fraud and abuse, right?
For the reasons that are set forth in fraud, abuse, patient neglect, or overpayment.
Mistake
We're not
in
talking
billing.
about fraud, abuse.
Mistake in billing.
Yeah. So all we could possibly be talking about is overpayment. This court has already determined what overpayment means. doesn't apply to prior authorized claims, and that settles the case. Now, they argue that, that the word authorized isn't referring to prior authorized claims, but they didn't cite any authority for that, and this court implicitly rejected that argument when it decided that prior authorized claims were barred. And it also makes no sense at all when the whole purpose of the 2002 amendment was to change this from a pay and chase model to a prior authorization model. That's exactly why that language is in the statute there. They argued that this retrospective audit program was a different program, and it wasn't what was covered by the statute, or this Gulf Court decision. But this court in Gulf Coast made it very clear that the plain language of the statute, and this is what Your Honor stated, the statute does not distinguish among the agency's different offices, nor does the office that conducts the review necessarily dictate the type of audit being conducted. The statute's very clear. Retrospective audits are prohibited, and that's what this court decided.
Could you briefly discuss with, I know you're getting short on time, but the appellee's argument about your failure to seek 120?
Oh, I don't recall that argument being made in the brief at all. But what's important is we certainly challenged these audits. We challenged them because they were illegal, and that we filed a lawsuit that has brought us before this court today, suggesting that the audits could not be conducted at all because they were conducted.
Which leads to the logical conclusion that your argument has to be that ACCA has no authority to review any overpayments for emergency services for unlawful alien medical services, right?
Not when they've been
Because
prior
your
authorized.
argument is you didn't seek 120, you didn't challenge it, your clients didn't challenge it. Your argument is it's illegal ab initio, right, to do any review.
It's not my argument. It's what Gulf Coast said. And
you don't think the legislature changed that?
The Gulf Coast said that, and the legislature had the opportunity to fix it if it wanted to. And so what I keep coming back to is if all this stuff that they were saying is right, why in the world was the statute amended in this very limited fashion? Why wouldn't you take out that first sentence in 505? Why wouldn't you amend the language in 409-913? That's what any sensible person would do if the legislature actually thought that this court got it wrong. But this court didn't get it wrong. Remember that this court—
What do you think the references in the House bill of final analysis to our decision in Gulf Coast? Do you think that was an acknowledgement that the Gulf Coast decision was correct?
Well, first, I don't think the court should be looking at that legislative analysis at all. How in the world does this staff in 2020 divine the intent of the legislature in 2002? I mean, there is no way that the staff who wrote that report has any better knowledge of what that statute means than Your Honors do sitting up there now reading the plain language. So and we also have to understand that when the staff report was written, the proposed amendment was different from the final amendment that was actually adopted. That original proposed amendment would have taken out that sentence in 505, but it didn't take out that sentence. In fact, it left that sentence intact, and it left 409-913 intact. And those were the pillars of this court's Gulf Coast decision. Nothing has changed, and for those reasons, we think the summary judgment should be reversed.
Thank you both for your excellent arguments. The court's in recess.
All rise.